everyone. Thank you all for coming tonight. Really excited to have you all here. I'm not sure if you've been outside today, but winter is coming. It probably might be here already. I'm Dunstan Barnes. I am the chair of the Young Members Committee of IPLAC. I don't know if you guys are familiar with IPLAC, so it's actually the oldest IP society in the United States. It's based here in Chicago. It stands for the Intellectual Property Lawyers Association of Chicago, I think. Joe will tell me if I'm wrong. The Young Members Committee actually won Committee of the Year back in May of this year because we put on great events like the event we have tonight. There was a rosé tasting back in August. Since then we had a trivia night, and we'll have a couple events coming up in the spring. So, you know, if you're not involved, if this is your first experience with IPLAC, I would say get involved. There's plenty of stuff coming along, and it's just a good way to meet like-minded people in the community. Tonight, we thought it would be a fun way to start things off with a couple of videos from two of our speakers. So we're going to have 4 TED-style talks, hence this get-up. It's not like a Napoleon Dynamite dance-off or anything. And so if you have any questions, I'd say save them till the end. There'll be a panel discussion after the 4 talks. After the panel discussion, there will be some Peruvian food and some drinks outside, so please hang around, get something to eat, get something to drink. For those of you active on social media, I figured out that the hashtag CKDesignEve seemed to not have any other hits. If you just did Design Eve, there are a bunch of random things. It's on the program. I think it's on the front of the program. So if you want to take photos, please take photos. Use that hashtag so people can find it easily. I want to say a big thanks to our sponsors for tonight. First of all, there's McAndrews, Haldon Malloy. It's the law firm that I work at. Our last speaker also works at McAndrews. Very design-focused firm. A lot of nice things to say about the firm. We also are sponsored by Legal Advantage. They provide illustrations. They're experts in providing illustrations for design patents, as well as utility patents and other services. A couple of other guys are here, Jacob and Jeff. They're in the back. They'll probably be around for the reception afterwards. And then also, thanks to IPLAC, IPLS, and C Delta. IPLS is the IP Law Society here at Kent. 6 years ago, I was in Mary's position as the president of IPLS. Going to have her come up and say a few words about IPLS and introduce our moderator for this evening. So again, thank you all for coming, and enjoy the show.
Thank you, Dunstan, and thank you all for coming tonight. My name is Mary LaFleur, and I am the president of IPLS here. IPLS is a student organization that educates our students on opportunities in IP law. We frequently have events like the one here tonight to educate students about substantive issues in IP law and career opportunities in IP law. Many of our students go on to practice IP law in Chicago and join organizations such as IPLAC. So thank you all for coming, and thank you, IPLAC, for inviting us to this event. So I'll now turn it over to our moderator for the evening, Professor Dinwoodie. Professor Dinwoodie is a global professor of intellectual property law here at Chicago-Kent and the co-director for the Center of Design Law and Technology. He returned to Chicago-Kent after 9 years at the University of Oxford and holds a number of prestigious awards and prepared a number of notable books and publications. He has also served as consultant to the World Intellectual Property Organization, is an advisor to the American Law Institute, and a consultant to the United Nations Conference on Trade and Development. So everyone, please join me in giving a warm welcome to Professor Dinwoodie.
Thank you, Mary. Thank you, Mary, and thank you, Dunstan. Dunstan asked me just to briefly say a few words, and I really will just say a few words of welcome on behalf of the IP program and the Center for Design Law and Technology, or C Delta, as we're known. Thanks, first of all, to the sponsors who Dunstan listed, but we're very, very appreciative of the sponsorship we get. Thanks to Dunstan and his colleagues at IPLAC for all the organization efforts they've put in, and to Mary and the IPLS officers as well for all the work they've put into. Before I introduce the 4 speakers and explain how we're going to proceed, I'm just going to say a couple of words about the Center for Design Law and Technology, because it's relatively new. It's part of our broader IP program. I probably don't have to say too much to many of you about our IP program. If you look at, just this morning, we distributed online the fall newsletter, and the range of activities the IP program engages in is very broad, and within the last 3 weeks, we've had the Federal Circuit sitting here. We've had a Supreme Court IP conference, which was extremely well attended. But C Delta is probably the newest part of our IP program. It was just launched earlier this year. In February, we had our first event. And it's really prompted by a couple of different impetuses. The first is the growth and the recognition that design is a really important part of our intellectual property policy, not just for commercial reasons, but also for social reasons. And I think you heard some of that, I think, from the designers this evening. And that important growing recognition socially and commercially has been mirrored, at least in the United States, probably within the last 10 to 15 years with a revival, I think, of the popularity of particularly design patents rather than other forms of design protection. I think Europe has probably had a more consistent level of protection over the last few decades, but there's certainly been a growth again in the last 10, 15 years in the United States. And strategically for us at Kent, it was an important area that we wish to lead in. We are the first design law center in the United States, indeed I think probably internationally. And part of the reason for that is that IIT has a very strong design institute, and we wanted to engage in some interdisciplinary conversations with colleagues who are not lawyers to broaden our horizons about the way we should shape design and the way the design should shape the law going forward. This event is very much that, as you'll see when I introduce our speakers in a minute. But before I mention the four for tonight, we actually have just to try and tease you a little bit in events beyond tonight. We have a series that we're going to continue all year on what is design, which will include presentations by lawyers and by non-lawyers. The first presentation is on November 14th. Sarah Burstein, who's a research affiliate of the center and a professor at the University of Oklahoma and has written quite extensively on design patents, is going to present a paper called Whole Design, which is about sort of reimagining what the subject matter of design patents are. And then we will have two non-lawyers, just to make it even more interesting, with all due respect to Sarah. Felicia Ferrone and then Chef Edward Kim of Mott Street Restaurant are going to give us talks about how the design process matters to them in their different fields of production and service provision. So that's to look forward to, but even more immediately to look forward to this evening, what we're going to have is four talks. I'm going to sit down and just come back up to moderate the discussion at the end, but four some TED-style talks from a designer, lawyer, lawyer. And I'm not going to introduce them extensively now. You've got their bios in the program, but just to tell you the order in which they're going to speak. So Rotimi Salola is going to speak first. Rotimi has received a number of awards for his designs. He also teaches at UIC. Elisa Abbott is a Banner and Witkoff lawyer who has an extensive design patent practice, will then follow. Then we'll have Joy Zeledon, who's also an award-winning designer, who will speak from the design perspective. And then wrapping things up, Chris Karani, who's a partner at McAndrews, and Chris has probably one of the leading design lawyers in the United States and obviously has a reputation globally. So that's what we're going to do. The four of them will make presentations. Then we'll assemble for questions and a conversation among the four of us, which I will moderate, and then you'll get your Peruvian food and drink at the end of that. So without further ado, I'll invite Rotimi to come up and take the floor. Thanks.
Okay, I'm just doing a test. Mic check. We good? Okay. How you guys doing? My name is Oluwadirotimi Sholola. I'm Nigerian born, so hence the long name. But you can just call me Rotimi, so that makes things a little bit easier. I'm an independent industrial designer, the founder of Show Design, which is my consulting practice, and an adjunct professor at the University of Illinois at Chicago, and I teach design visualization. So I work, I teach, I learn. Before I became an independent designer, kind of doing my own thing, I used to work at Motorola, where I helped work on this product, which is the Moto Z 2017 model, which was our shatter shield technology, guaranteed not to shatter when you dropped it. And it was like 6 millimeters thin, a lot of innovation with engineering and technology. And that's what I really, really thrive in. So a lot of the work that I do is revolved around technology and just forward thinking within design. Fast forward to today, I'm the founder and principal and everything else for show design. It's currently a one-man operation, but visions of growing. And basically, there's two parts to the business. The business is a consultancy where I work with small businesses, individuals, and larger companies to visualize and represent their product goals and help them bring products to market. I also work on my own product line, which I help bring to market as well. So we're going to talk a little bit about a couple of those avenues. Before I get started, I just kind of want to get a lay of the land. How many of you are designers? Okay, so all three of you. Great. So the rest, I'm guessing, are in law then, right? And then some others that on their way here. So that's great. That is great. So I'm going to give a little bit of background on industrial design. And you might hear from other people when you ask them, what is industrial design? Well, it's the design of everyday objects. I'm going to take it a step further and say it's design of everyday objects, interactions, and systems, okay? And in a nutshell, industrial designers make ideas tangible, okay? So ideas are this ethereal thing that everybody has, and my job is to just bring it out of your head and figure out how we can make this as real as possible in the most effective way, okay? And that's what I do with my clients. So I'm going to give you a case study that can help kind of talk through a little bit about my design process, what it means to me and the clients that I work with, and just kind of a day-to-day interaction. So I'm going to tell a little story here. So this is my story. Go now. One of my clients is Stride, all right? And Stride is, at the time, they were a startup. I guess they're still a startup. I don't know what the threshold for a startup is. Is it 5 years, 2 years? I just don't know. But they were a startup. They launched on Kickstarter, and they wanted to create their second-generation product. Well, Stride is a technology company that focuses on athletics and running. And they have this technology that's about this small, and they put it in a form. Hence why they needed a designer to create this form. And with that, they can gauge the amount of power that's in every step that you take when you're running. Now, they're a Colorado-based company, so they're really big into running outside because there's just amazing mountain ranges and views when in Colorado. So that was something that was very important to them, and they wanted to bring that heritage or that particular style of running. They wanted to really play it up with the design, okay? It wasn't about training in the treadmill. It was really about going outside and experiencing. So that's a little bit of background on the company, okay? So fast forward to receiving, I guess, an email and jumping on a phone call with this company. And we talked through the brief, and they're really looking for a forward-thinking new encapsulation for their technology. Something that can be easy to use and really striking to sort of compete with the Garmins and the other brands that people are buying. And so the conversation went a little bit like this. I'm going to paraphrase a little bit in my own way. So I get on the video chat and I'm talking to them, and we're basically they're talking to me about their heritage, and they're saying, okay, well, we want to make this product. It's a small product. It's going to sit on your shoe. You're going to run with it every day. We want it to be incredibly lightweight, incredibly sleek and fast-looking, and just really cool. Oh, yeah, and we also want it to feel like a mountain. And I said, wow. Well, mountains, I'm not sure how fast or lightweight or sleek they are, but I'm not sure I understand. So no, it's got to be like a mountain, And so, okay, I took a stab at it. I was like, okay, I did some design iterations, handed it off to them. They were like, okay, these are decent designs. They're not what we're looking for. I said, what's the matter? These are too sleek. I said, okay, yeah, they're too fast and they look too light. I'm just like, oh, well, what's wrong with that? Well, that essence of the mountain is not there. Right? So then I started to dive deeper. Okay, what is this? What do they mean by this mountain? And I realized, well, it's not necessarily this idea of the mountain, bringing that and putting it on your shoe. It's this idea of nature, right? This idea of being outdoors and the striking views, okay? So I started to distill that and abstract from nature, because I can't just take a mountain and make it into a product. That's not how it works. So I have to create imagery or pull imagery and see how I can abstract those graphics that these guys have in their mind, pull it out of their mind and start to create something from there. So there were two key things that inspired the design of this product, and that was mountain topography and ripples from a drop of water. All right, so that starts to give you that theme of nature, but this is a very tech-centric product. So fast forward to several months later, the final design is this foot pod about an inch in diameter. I would say it's fairly sleek, fairly lightweight, and kind of has that essence that they were looking for. The client fell in love with the design, and that was, the rest is history. We've been working together for a couple of years now. And that's just a view of how much technology that they were able to fit into this tiny pod. So these are the types of solutions that I work with clients. And this is actually a photograph of that product. So these are all computer generated months in advance before this thing actually came out, and this is how it ended up. Okay, so this is what I mean when I say that designers make ideas tangible. Even before the product came out, they knew exactly what it was going to look like, exactly how big it was going to be, how it was going to feel, the emotion that you were going to get out of using it, unboxing it, and that's kind of what we're doing here. I talked about design being systematic, right? We start to not just look at the product itself, but also the packaging and the unboxing and the experience of opening that box for the first time. This company does shipping directly to consumers, so there is no storefront, although they're probably looking to do that in the future. So I have to look at when you get that cardboard box and you open it up, and then you open the little box within the box, and then you pull out the little product. So start to look at all of those and try to create a meaningful and unified holistic experience that pulls back into the brand, all right? And this was, I would say, a successful attempt at that, because they haven't fired me yet. One of the really exciting things about leaving my job at Motorola and stepping out into the world of not knowing when the next paycheck was going to come is the fact that I get to work on things for clients and other people, but I get to work on things for myself as well. And one of the things, this is getting a little distracting, I'm sorry, I can't pause it. But one of the things I got to work on is a product brand. I'm building a brand, it's called the Alt brand. And I launched the product, Alt Pen, this guy right here. It's getting there, it's becoming tangible. And that was the first video that you guys saw earlier tonight. And basically, this brand was created to develop products that had multiple uses for consumers, something that you may carry on you every day and unfold, and it can do more for you. So I've got a really brief video here on just kind of demoing some of the colors. This was an advertising campaign I put together for the Kickstarter that launched over in the summer. And basically, like I said, Alt Pen is an instrument for writing, and it's also a tool as well. So that's sort of the dual functionality. We could talk a little bit about that. But the idea started when I was back at Motorola, and they had sent me to a trip to China, and I was working with the manufacturers. And there was an issue, and I needed a tool to solve the problem, basically. And I didn't have the tool. I didn't have my tools. I have about a 100-piece tool set at home, but I didn't have it with me. And so that's when I really started to think, okay, I need to always be prepared. Even though 90% of the time I'm not going to need it, but 100% of the time I always have a pen on me. So that's really where the idea came. And so normally someone has an idea, they may call a designer, a patent attorney, an engineer. Well, fortunately, I'm a designer, so I just looked to myself. I said, okay, well, let's figure this out. Let's come up with a solution for problem that you and 5 other people have, okay? And so I came up with the alt pen, and that is uses a proprietary fitting that allows you to basically remove the ink cartridge and swap it out for a whole array of precision tool bits. And you know, I always start from the drawing board with any project. I didn't show many of the sketches on the last project for proprietary reasons, but I always start from the drawing board, paper sketches, on the train, in a cab. I'm the guy that's like sitting there like holding the CTA line trying to sketch. I don't even know if it's floating or what's happening there. But I try to create as many ideas and come up with as many different forms and try to solve the problem from as many different angles as I can. And with this the main constraint was, well, it's got to be small, it's got to fit in your pocket, and you got to use it every day as a pen. It can't be an amazing tool and just a terrible pen, right? So after you go from the drawing board, now you have to start to make it even more tangible. So there are layers that we can peel back, right? First the idea, then the sketch, which is more tangible than the idea, but still pretty loose, and then prototypes. So using 3D printing technology, I was able to pull together some volume studies, put some magnets in them, actually make them work, you know, more or less, and use them. And once I got to a point where I was happy with the proportions, I needed to make some phone calls, and I got on a plane and found myself in Shenzhen, China, working with some manufacturers. And we created, I think we're on prototype iteration number 7 right now, and you really realize how tough it is being a business owner when Motorola is not paying the bill for prototype R&D, right? So, but it's all part of the process, and I really enjoy it. And shortly before this, I actually worked with McAndrews and Dunstan and Chris Karani on design patent and utility patent, provisional patent for this product. So it was really cool. I got to meet these guys several months ago. And oops, spoiler alert, we made money. Okay, let's see if I can get this right. Play. Okay, there we go. So this was part of, you know, some snippets from the Kickstarter video that we launched, and it was really about, I really like this 30-second clip because it just shows the entire story in a nutshell. It's this product that you can use to draw or write, tell a story, and you can use it to fix things, your glasses, your phone, all types of things. It's really endless possibilities. So that's just an array of all the different prototypes that we went through at the time of this. The time of this video, we had gone through about 3 prototypes. Now we're about 7 prototypes in, okay? And we were successfully funded over a 30-day campaign on Kickstarter. We rose 180% of our target, and it was about over 500 backers. So that was pretty exciting to see that I wasn't the only person that needed this product, that there were other people, even though I really did just designed it for myself. So one of the perks of being a designer. This is what the product looks like today in the packaging, which I also made sure I designed. I actually had some interns this summer which helped me with the packaging. So again, for me, design is more than just a product. Industrial design, though it's an object-centered design discipline, but it's about the system and it's about the interactions. And for me, that includes the packaging. Okay, when you get that, what is that experience like? And to me, it's just really important. And that's what the product looks like. I just keep saying that. That's what the product looks like. Let's see what's next. Okay, that's it. So, recap, ladies and gentlemen. Industrial designers, they make ideas tangible. That's all I have for you today. Thank you.
Okay. Can you guys hear me? Yeah? Okay. So I've never used one of these things before, so if I look incredibly uncomfortable, it might be because I am. So please forgive my awkwardness. So my name is Elisa Abbott. I'm a design patent attorney at Banner & Woodcoff in Washington, D.C. My practice is primarily design patent prosecution and litigation, a little trademark and copyright on the side. So today, let's see how this works. I'm going to talk to you mostly about design patents, giving you an intro, and then sort of comparing them to the other forms of intellectual property protection you can get. So basically, this is the next thing that you do after you design a product like Rotimi was mentioning, the really cool pen or the little pod that you put on your shoe to make sure that the visual appearance of it is covered. And then I'm going to tell you why design patents are the best. So design patents cover a lot of different things. I'll run through the list really quick. And everyone pay attention because there's swag involved. So first and most obviously, design patents cover, meaning when I say cover, I mean they protect. Ornamental features that a competitor might copy, shapes of physical objects, so like a bottle, printed patents, so maybe like a particular camouflage pattern. For example, you could probably imagine the camouflage pattern that is associated with the Army. It's kind of like pixelated. And, oh, that's a really cool graphic I added. Graphical user interfaces, what's on the phone screen that you might be looking at right now. Like icons, animations, how things move across the screen, and portions thereof. So that means like maybe one section of the screen, one part of the bottle. Now, when you're looking at a design patent, which I'll show them to you shortly, keep in mind the solid lines represent what is actually claimed in that patent, and the broken line just shows like an example environment. So for example, you might see a Coca-Cola bottle, and the bottom of the bottle is in solid lines. That means it's claimed, and the cap is in broken lines. That means it's not claimed. So it's not actually part of the patent. It's just being shown there for environmental reasons to give the claim some context. So first, ornamental features that competitors might copy. A really good example is the shocks on Nike Shox. So you'll see, I guess it's on the left. It's kind of hard to tell because it's sort of a small feature of the shoe, but that's the shocks on a Nike Shox. And then on the right are some crap shoes from Walmart that tried to copy it, and obviously they did not get away with that. And then also we have these beautiful UGG shoes that have this sort of folded over shearling appearance. And I'm sure you guys have seen loads of UGG knockoffs too. So that's just an ornamental feature, a part of that product that the design patents cover. And then we also have shapes of physical objects. I mentioned a bottle before, chair, tires even, and then I don't know why somebody got a patent to a porta potty, but it's there. Then printed patents, like I mentioned with the camo, we have a paisley print, and then this is a printed pattern inside of a shoe. And there's that image again. Okay, can anybody guess what this graphical user interface covers? Yes, good job. You get some swag. You can get it now if you want, or later. Okay, and by the way, this is really good swag. This is a Yeti mug, so get involved. Okay, so yes, that is a Coke machine, where you like select the different types of like soda flavors and stuff. They have them at the movie theaters and like, I don't know, Noodles and Company and all that kind of stuff. So that is an example of a GUI. And then this is an animated one where you can see like in the different figures, the icon sort of fills in. That was for a Nike product. Other good examples are what is on your phone right now. And these are things, you know, you see everywhere. So the microphone in Google Voice Search, that's an example of just like an icon by itself. And then here's several examples of portions thereof that a competitor might try to copy. An example is the band on top of Lululemon pants. They might not copy the rest of it, but that band is a signature look. Different things on your home screen of your phone, like maybe just the slide to unlock feature, or maybe just a certain portion of headphones, maybe just a certain portion of the car. So you can really kind of like make your claim cover the entire product or just like little sections of it. It kind of depends on what is going on in the market right now, what you think a competitor might copy. So black letter law, design patent is going to cover a design embodied in or applied to an article of manufacture, not the article itself. So what this means basically is that a design patent has to be on something that's functional or useful, but the patent doesn't actually cover the functionality or the useful part of it, and it really shouldn't. So there's a lot of overlap with design patents and other forms of intellectual property. You're probably thinking like, wouldn't a copyright cover this, or trademark or trade dress, or maybe something show up in a utility patent? But they're really their own thing in a lot of ways, and I'll explain why in a second. I will note though that they can be used with a bunch of other different types of coverage, and I'll give you some examples soon. So just to compare and contrast, design patents compared to utility patents. So two main types of patents: utility patents, novel, which means new, and useful or functional. So useful or functional could be like the gears inside of a watch or a computer program inside of your phone. Whereas design patents cover something novel, new, and ornamental. That means something that is applied on top of that article of manufacture, something visual. It can be functional, but that can't be the main part of it. Oh, he was just waving at me. I don't know why. Okay, so here's an example of a useful or functional item. It's a windshield wiper. This is obviously a super old patent because of the way it's drawn. So that's new and, well, new then, and useful or functional. Okay, another question time. What do you guys think this patent is? Yes, good job. You get a treat too. Good job. It is Velcro. Oh my God. So that's a useful device. You can see it's like hooked on and pulling apart. Here are some other useful devices: a beer umbrella, and I just found this one today, a mistletoe headband, which I thought was kind of funny. Okay, now design patents. So this is a little bit different. It has to be put on a functional or useful item, but it's just the ornamental side of it. So here's an example. A perfume bottle. Obviously, the perfume bottle has a function. It's like a canister that stores a liquid, so it has to be able to do that. But the visual aspects of it don't need to contribute to the function of it. So here, the fact that this is sort of like, I don't know if it's like a octagon shape or something, that the shape of that bottle doesn't contribute to the function of it. And these are things that we see every day, like all over the place, whether you're on your phone, on your computer, shopping. Like when I first got into this, I was shocked at how many things have design patent coverage. So example, Balenciaga perfume bottle. Here's another good example. Does anybody know what this is? No prize involved, because it's really easy. Yep, there you go. So that is, oh, wait, go back. So here's another way to think about the ornamental and functional part of it. So there are a lot of ways that you could think of this being functional. Like maybe the fact that it's sort of U-shaped lends to the ability to scoop up like sauce or something, and same with the ridges. But those don't have to be there for it to be functional. So it's not like you have to have one or the other. So that's kind of why it can get design patent protection. So a few things that distinguish design patents from utility patents. I really went wild with some of these appearance things. So you can only have one claim per application. With utility patents, you can have a zillion. You get 15 years of protection after the patent is granted. And the main thing about design patents is the drawings show the scope of the claim. In utility patents, the words are really, really, really important. And the words are important with design patents too, but they're just so much shorter because since it's directed to the visual appearance of a product, the drawings are the most important part of it. So you can see here an example of a Yeti mug. There's the actual product, and then different portions of it are being claimed. We have the whole visual appearance, the bottom, and like the portions of the top and the bottom. And this basically means that if somebody were to copy certain parts of that and maybe not the top part and use something different, you could still get coverage. So again, just to reiterate, design patents cover ornamental features, shapes of objects, printed patterns, GUIs or graphical user interfaces, and portions thereof. So here are a few good examples. You guys probably remember or recognize a bunch of these. Handbags, Xboxes, food like an Eggo waffle, phones, cars, there's like a Lululemon top in the corner, all sorts of stuff. Okay, now to distinguish design patents from trademark and copyright. And the main thing I'm going to focus on here is just with product configuration, because copyright and trademark can get a little complicated, but when it comes to product configuration, it's easier to sort of distinguish between them. So on the left, we have a Coca-Cola bottle, like I was talking about before. You can see that the shape of it is totally ornamental. You can make a bottle that is easy to hold or contains liquid in that same way, but doesn't look like this. So really the functionality of it is just sort of like a side effect of it. So again, design patents and ornamental design applied to an article of manufacture. Copyright is a little bit different. So original work of authorship that's in a tangible medium of expression, but it has to be separable from that medium of expression. So an example is an emoji. It's original, it's fixed in a tangible medium. So like on your phone or on a piece of paper or whatever, but it doesn't have to be on those things. It doesn't have to be on that particular article of manufacture or whatever. And then trademark and trade dress, you guys are probably most familiar with these. It protects words, symbols, names, anything used in connection with a device in commerce, sort of distinguishing that particular brand and associating it with that particular good or service. But when it comes to product configuration, you need to have acquired distinctiveness. So obviously Coca-Cola, we get that, that's a trademark. But when it comes to trade dress and product configuration, you need, in order to get coverage, you need to show that that particular look is associated with that product. So even if I didn't tell you guys that was Coca-Cola, on the far left, you would know that that's a Coca-Cola bottle because it has acquired distinctiveness. And you might think the same thing of a Yeti bottle. You know, if you look at this silver cup in this particular shape with this clear lead, you'd probably, you've seen them around enough that you know it has acquired distinctiveness. So that would be the trade dress aspect of that. Now, as you might have surmised, in a lot of different circumstances, you can have all sorts of different types of coverage for your product. An example would be Nike shoes or this Yeti bottle. So with the Nikes, you've got design patent coverage, like the appearance of the squishy sole on the bottom or the knitted part on the top, and then trademark, the little swoosh, copyright maybe, and then utility patent probably on maybe the way that the strings hook to the laces or something like that. So if you have a product that is going to be selling big time and people are going to be knocking off, you're going to want all these different types of protection for it. And in some circumstances, design patent might be the most important kind because the visuals are so important to the design. So what's actually the benefit to this? And why have people been using them so much lately? So what's great is that you can file them and prosecute them just like utility patent applications. So if you're already working on utility patent applications, you can sort of like proceed knowing how to do it. And they can also be significantly less expensive. And one of the reasons why I'll explain in a second, but there's only one claim per application. So costs can still sort of slowly accumulate. They also have a shorter pendency, so once you file it, it's maybe like 2 years until it's allowed, maybe less, maybe a little bit more. You can have portion claiming on the visuals, and applications can be quicker and easier to prepare, hence why they cost a little bit less. And then you can get infringers' profits, which is very unique to design. So why are design patents so popular now? So filings have increased in the past like 5 to 10 years a lot, even though they've been around for like over 100 years. So this is, I think, the first design patent, maybe? Oh, no, it's the 17th one. I actually don't even know what this is. So I couldn't make you guys guess. It's a stove? Okay, so it's a stove. But it was patented in 1844, so it is old. So they've been around for a really long time, but people haven't been using them a lot until recently. I don't know if you guys have heard of Apple and Samsung just going at it, but this is probably one of the reasons why design patents have been filed a lot lately. So why now? Well, products with screens are just everywhere now. Literally everything you use has a screen in it. I was in a hotel a couple months ago and the mirror had 3 different screens in it. Like, what are you even supposed to do with that? So everything you're using has a damn screen. Like, your watch has a screen, the car console has a screen, like your fridge might have a screen, the mirror might have a screen. It's kind of excessive. But when all of these things have all these different patentable aspects, the companies are going to want coverage for everything. So a good example is a phone. There's 2-dimensional and 3-dimensional aspects of it. Here we have an Apple phone, and then also the shape of the actual Apple phone. So what shows up on the screen and what the phone actually looks like. They're going to want coverage on both. And like I was talking about before, since everything has a screen, we're also doing more things on screen. We're reading, shopping, doing homework, like maybe you're going to class by watching a lecture from a professor, that kind of thing. So your only interaction with a particular brand could be just on your screen. A really good example are dating apps. The only time you're not on the screen with that app is when you are on a date. So how that is visually presented to you is really important. Even Google has a design patent for like the most basic part of their appearance. So you can even protect animations on screen, the way things show up on the screen. I think this is a Facebook-like, maybe? Does anyone think it looks like Facebook? I'm not really sure. But so you can protect like the sequence of the way things come up on the screen. Now, there has to be some sort of like a monetary benefit to this if people are wanting to file, if companies are committing so much money to filing more of this. And the reason why is because when it comes down to suing people, you can get more bang for your buck. So with copyright, you've got to prove copying. There's a substantial similarity test. And it can be really hard to show that somebody that was working on a product was doing literally taking your work and using it. And it can take a lot of money to kind of put that evidence together. There's also a lot of money involved with trademarks and enforcing those. The likelihood of confusion tests can incur a lot of costs from surveying consumers to see, would you be confused by this fake Yeti mug by this real Yeti mug? With design patents, you don't need to survey consumers. It's just an ordinary observer test. Is the accused or potentially infringing design substantially the same in the eyes of an ordinary observer, which is literally anybody in this room? So here's a really good example of a complaint that just came through. If you would as an ordinary observer, if you would look at these chairs, you would probably think they're from the same company. Maybe one's very slightly different from the other, but they're pretty much the same. The one on the left costs a gazillion dollars. I actually went to the website, and it was one of those things where it was like, inquire if you're interested in purchasing, because it costs so much money. And then the other one actually was like $2,000. So it's ridiculous. But it's basically like a $2,000 design knocking off a probably $10,000 design. But this complaint just came out, and I think that I went to the Olivia Stone website and they had already taken it off the website because it was so obvious. Once they got sued, it was so obvious that they were screwed that they just finished it up. And we've got another final example with these ALO yoga pants that I'm sure a bunch of you have seen around. They're over $100, and this other company tried to copy them, and again, went to their website, they took it off the website. It's like lickety split. If you've got design patent protection and you send them a cease and desist, they can just take it off really, really quickly if it's obvious. So, and if they don't, then you can get a bunch of money from them. So since I'm running out of time, I won't go over this because it's a little bit too much. But basically, the theme of the story is that design patents kind of have a relationship with utility patents and copyright and trademark, but they're really their own thing. So use them on their own, but also in conjunction with other products. And my last swag question is, how many Lego guys did I have in these slides? Whoever gets the best, closest number wins. 7? 23. Who said 17? You win. There were 15. So, okay, you guys can come over to me afterwards and I'll give you your treats. Okay, thank you.
All right, everyone. My name is Chris Karani, coming from McAndrews. Really great of IPLAC and Chicago Kent, the Design Center, to put on this type of event because it's been too long to have this conversation between designers and the legal profession. I've been practicing in this area of law for a good 20 years and have been hearing these conversations where you have designers speaking about one thing and then you look at the law and the things that you could actually do for them, and there's a huge disconnect between the two of those things. So one of the things that I wanted to sort of talk about here today, and I'm really looking forward to the discussion with the designers, is talking about some of the underlying policy reasons that are behind design laws in particular. And are we meeting any of these goals of the designers? There have been aspects when we heard Rotimi this morning talking about that they take ideas to make things. You sort of take and make those tangible. That was that aspect of it, so the tangible things. And the design law does a really good job, I think, in the context of actually protecting that. But when you hear so much more about this user experience and those type of more touchy-feely things from Joey's book, that's where the law really struggles. And we have to ask ourselves, do we want it to even delve into those areas? And is it something that's even feasible? Alisa really teed it up here nicely, so setting forth a really nice overview of the areas of design IP. And I think that's one of the other parts, is that this area of the law, it's this burgeoning area of the law, that phrase hasn't even been used so much, this idea of design IP. And I think it fairly encompasses this, and when we're talking about protection of aesthetics, you would be totally wrong to sit there and just put on a design patent hat and think about it only through that particular lens. If I do get a product from a particular designer, I'm going to think of it through all the things that Alisa was talking about with respect to design patents, utility patents, trade dress, copyright, and any other types of rights. So you really, it's a broad area where I've practiced utility patent law for a long, long time, but I find most of my colleagues in that area really just focus on that particular area. They probably had experience dealing with copyrights or trade dress or trademarks through law school, but really in practice, being fluent in all of these areas I think is one area. Once you get into design, you really have to be fluent in each of these areas of IP law. In fact, last year here at Chicago Kent, I had the pleasure of teaching a course called Design Law, and we were able to go through sort of all of those areas of IP. So let's just add in a couple policy things, but and first I just want to talk about the area of design law, and Alisa was right to talk about it's really having this renaissance over the last 5 years, largely with respect to Apple v. Samsung, that brought things to the forefront. This is a little sort of amusing that I put together. I just happened to stumble across it, and I thought I'd share it with the group here. In 2008, I happened to, at the Art Institute, they had this Raft of Medusa painting here by Theodore Géricault. And it's basically these people who are castaways on a boat, and they're suffering, and they're gazing towards the horizon, and there's a boat that's passing, and whether or not their SOS signs will be heard is sort of what's going on in the painting. What was going on in 2008 in the world of design, and I see we have a couple of the colleagues, practitioners who were certainly practicing at that period of time, it was a really dark area for designs. Almost every area of design patent jurisprudence, from the law on infringement to the law on validity to claim construction to damages across the board, it was just getting a very grim situation. In fact, a group of us had put together a league to try to present some legislation to scrap the design patent system and go with just a registration system. So you don't have to go through the whole process of applying for design patents at the USPTO, which is an expensive process. Much of the rest of the world, it's a strict registration system. So it's almost akin to a copyright. You file your design at the relevant local authority, and you will get a registration that you can enforce with that. Very different from the US system, where we treat them as patents in the sense that the examiner is going to look up all of the prior art. They're going to vet those against the statutory requirements. Is it new? Is it non-obvious? Is it not functional? Is it definite? All of those things, it's a very costly process. And we were wondering, is it worthwhile to go through all of that? You talk to designers, and the value proposition is suspect on a lot of designs. Well, with time, you can see in the distance, and I know the font's really small, but you see a little boat over there. It says Egyptian goddess on the mast, okay? And that was, at that point of time, it was the first and only Federal Circuit case, that's the appeals court who handles patent cases, that was heard en banc. And it really did sort of, was a course correction for design practitioners and the design law. You don't have Apple winning the $1.05 billion judgment in Apple v. Samsung if you don't have Egyptian Goddess, which was about 5 years prior to that. That really liberated things with respect to no longer do we take design claims and try to write them out and try to translate them into words. No longer did we have this troublesome point of novelty test. I won't get into it, but we sort of cleaned up the test for infringement, making it much more possible, so giving design patents teeth. I always knew that it was going to be on an upward slope after that point. Obviously, Apple v. Samsung came along, and then the slope increased greatly. Elisa went through these various regimes of IP law, but I want to be, when we go through these, it's really important to understand the policy reasons for each of these, the requirements for each of these, the term that's each, the protection. There's a lot of similar terminology. You might use the word functionality in your trade dress class or trade dress law, but that means something very differently in design patent law. So it's wholly improper to grossly appropriate a term from one of these branches and bring them to the other. I'm not going to go through all of these, but when we think about each one of these, you can't just pull a term from one and assume it's going to be in the next. There's sort of a careful balance for each one of these of what's required and what's the policy, even in if there's injunctive remedies or the damages or profits that are available. Okay, so a few thoughts, my thought here in the presentation was just maybe some food for thought, and we can talk about it at the reception afterwards, or just plant some seeds in our head, and particularly with the designers here. This idea of the idea-expression dichotomy. You might have learned about it in copyright law, in your copyright class, and it's this whole idea that you can protect an expression, but you can't protect the idea. So by way of example, you might have an idea. I've got the idea that I want to make a computer mouse in the shape of a turtle, okay? And you'll have clients that come along with an idea like that. And this is something sort of fanciful, but you can imagine an idea like that. The thing that the law is going to protect is going to be the expression of that. It's going to be that particular. And that's much to the chagrin of a lot of designers, where they want to have well, this is the idea that I want to protect. I'm not really so interested. I mean, the expression, I can go and change that. Someone can design around it. Where the law is it's very far on the right side of that to the expression side of things. So you're not going to be able to get this concept of just a generic mouse in the shape of a turtle. And as much as you'd want that protection, that's not where the law is. And it does make you wonder if it should drift more towards this more sort of genericized type of protection, but that is not where it's at. It's very much in the expression of what you get. Now, there's a lot of things, and Lisa was bringing up today about claiming portions of the design, and maybe disclaiming portions, or maybe you'd only claim sort of the top shell where it hits a portion. There's creative and strategic things that you can do to get to that point, but largely, it's only the expression. So, by way of example, if there was an infringement case, the one on the left, if that's your design right, the product on the right, yes, it's a turtle and a mouse, but it's the same idea, but you're not going to have infringement. And that could be sort of upsetting because really the novelty largely here is that sort of combination of that ideas, not the actual expression. But that's one thing certainly to keep in mind as we go through this. The other thing, which I think has to be really a bedrock when you're thinking about designs, is that designs protect appearance, not the underlying functional attributes. And it's very difficult to divorce yourself from any understanding of how something works and thinking about function. Many of the time, if I'm before a judge or before a jury and you're arguing these particular cases, opponents, if they're not really well-versed in design, they might start arguing, well, Your Honor, see, ours folds like this and their folds like that. And that's where you have to educate the judge, you have to stop the other side, is that the designs are not protecting any of the function whatsoever. In fact, what I usually encourage people to do is look at something like this as if it's faux, F-A-U-X. That in other words, even though there's hinges that you see on that, and you probably use this product, and you know that it folds with those piano hinges, those are not part of the design at all. It's only that appearance that it has that. So whether they work or not is completely immaterial to the analysis. So it's only the appearance. All right, so what are these things that are governing how the design law impacts how design impacts society? Okay, and so what I wanted to sort of explore and probe here, and I'm really looking forward to hearing from the designers, is that how we phrase our infringement test, in other words, how close is too close, is going to determine competitors how close you're going to get to your design. During Apple v. Samsung, I was very curious because if you think about the time leading up to that case, it was basically Apple would come out with a new product, and then all the other competitors would see how close they can get without sounding alarms, and then Apple would come out with another product, and everybody would see how close they can get. And after that particular case, when there was a finding of infringement, what my experience is that I've seen in the market is that the products seemed to be had at that point, gave a little bit more space to that. And I think that's one of the things we get from how we define infringement. If we define it very, very narrowly, the competitors then can get very close. If we give more breadth to it, competitors are going to have to get further away. And when they get further away, they're going to be coming up with their own sort of groundbreaking, their new particular types of designs. Even in Apple v. Samsung, what we saw from all the paperwork and the discovery that was done in the case was they had a whole bunch of other really cool designs. In fact, year after year, Samsung wins a lot of the Red Dot Awards, which are some of the highest awards for designers. But in this particular case, there was the business unit saying, no, we're not going to use those. We need you to use a proven winner, and the proven winner is what the iPhone looks like, so we want to get particularly close to that particular design. So the infringement test really does inform how designs. Now, I'm not so foolish to think that the design world revolves around design patents. It's not that, but it is part of the equation. And when you saw Joey sort of showing those particular areas with the business feasibility up there, that is certainly this component. Are you going to go to market with a product which you can't protect? If you can't protect the design of it, and you could think, I hear sometimes say, well, just design patent protection, but think about this in the context of an online marketplace. I mean, that's everything, is that visual when you're shopping on Alibaba, if you're shopping on Amazon, whatever you're doing, it's that point of sale right there. It's the appearance certainly reigns supreme in that particular context. So Gorham v. White set forth what was a policy reason. This is the Supreme Court in the United States after Apple v. Samsung. This was the previous time they spoke about designs. Is in the case of Gorham v. White was regarding those two spoons. They've set forth that the acts of Congress which authorized the grant of patents for designs were plainly intended to give encouragement to the decorative arts. So here is the policy reason that they're citing or they see within the Constitution in the Intellectual Property Clause Act of what is the policy reason. We're trying to encourage the decorative arts. Now, that seems quite altruistic, and of course there's the desire to want to make products more saleable and people to protect their markets. But they thought that that was a meritorious service to the public. So are we achieving that when we're setting our sort of the needle as far as how close is too close when we talk about infringement? They set forth the test. It's in the eye of an ordinary observer, not in the eye of an expert. They don't want an expert's. If you set the needle that finely, then there's going to be all sorts of. They're never going to find infringement. Here they set it within the eye of an ordinary observer. And the test for infringement, a lot of times you have to use these type of phrases in law in order to give enough elasticity to the test, is that they need to be substantially the same. So they could have said identical. They could have said strikingly similar. They chose this phrase substantially the same. So there is some breadth in there. Of course, examples is going to be the only way to really mete out how broad that test is. So Gorham v. White, if we sort of lay out this particular analysis, you can see the patented design there, second from the right. I like to lay these out always, whether before a judge or a jury, chronologically. And this is what I tell my class, whether here at the class or at Northwestern, is line them up from left to right. Put the prior on the left, put the patented design, and then put the accused product. It tells the story. In this particular case, the prior art does tell you what is there. And we heard Joey talking about the 80-20% rule, 80% familiar, 20% new. Now, in this particular situation, you can see that there's quite a bit that's similar to the patented design. You might even wonder how this patent was granted in the first place. But this wasn't the prior art. This is just me musing and putting up hypothetical prior art. Here is what the prior art would have looked at the time. So just imagine yourself that you have the prior art at the time. You see these very ornate, almost Baroque-esque type of designs. Then Gorham comes out with its flatware design. It's minimalist. It's sort of it's in its design. There are very little elements in there. Then White comes out with the product, very similar to a lot of the situations that we see now. And in that situation, the finding was infringement. So when we do design, you very much do need to look at the context of what the prior art. And this is different from utility patent law. We don't go through this exercise of looking and comparing the utility patent claim against the prior art claims for purposes of infringement. But in design, it's a critical part of the analysis. Now, a quick query there is because in this case, and by the way, when we have Peruvian food, I think, we can't use these to eat on, but I have the spoons from Gorham v. White, which I'll be happy to share with the group, that a good expert witness had gifted me these at one time. So they're the actual spoons from the case, and anybody that knows me knows that I'm all too happy to share them with people and show them. So the spoons, we can look at them, but one thing you learn from this case is that they're quite different. I mean, there's a lot of similarities between the two, but they're different not only in detail, but also in shape between the two. The Gorham's patented design was sterling silver, and of course the accused product was selling for a fraction of the price and was plated silver. So it's the sort of same old story that we hear now 100 years later. But in the case, the court really gave a lot of breadth to the scope of design patent. In fact, it said the controlling consideration was the visual impression upon the eye. So it wasn't going down on a very granular level. Instead, it was coming up on this impressionist level. And sort of through research, I've learned that in 1871, which this case comes down, is the same year that Monet unveils his Impression Sunrise, which is this painting. So there's one connection, what's sort of going on in the world when this test was being created as far as Impressionism, but also that Justice Strong, who wrote the opinion, Gorham v. White, which is the granddaddy of them all when it comes to design patent infringement, was a big fan of Impressionism. It wasn't called that back then, but in his chambers at the Supreme Court, he had many of the paintings. So in a sense, it really sort of pushed it and gave a lot more breadth to this. Now, there's all sorts of other checks. That's one check that we have on there is with respect to the infringement, but also with respect to all of these other defenses. Now, on the defenses and the requirements, so what are we going to require for a new design? And this is more probably than anything that sort of, I think, drives or can drive design. Look at here at the 1957 Chevy Bel Air, and you can see the design up on the top. And the very next year, a 1958 Chevy Bel Air. And if you look at those two designs, it's amazing that there's a car company having a major release of one of its platform products and having this degree of design difference between the two products from one year to the next. And you might be saying, well, Chris, was that 1947 to 57 and then 58 to 68? Here's the next one, from 58 to 59. Look at the differences in design. These are very large leaps in design. I think Rotimi was mentioning sort of iterative design. These are large leaps in design. And is this what the law sort of would require? If the law required this is the type of steps beyond the prior that you would be seeing. Now, in recent years, I think it's fair to say that the test, at least the needle, has been set so much more finely. Let's take a look, and I just was recently shopping for an iPhone, and I'm sort of amazed at this. Look at this. There's this iPhone 6, 2014, and here's the iPhone 8, September 2017. Now these are just the products, but I can tell you now that they both received patents. Okay, so both of these products have design patents covering this particular design. So this was enough of a step for the U.S. Patent Office to say, that's enough of a step beyond that. Now, you might be thinking, well, what's so bad about that? Well, one thing to think about it is that the monopoly, effectively, of that particular design is going, because the first one was, 15 years, let's say, from the first one, and now when you're coming up with it again in 2017, you get another 15 years beyond that. So by having these small steps, how it impacts design is a very interesting question, because large steps, if we require, and again, this is to the extent that design law is actually impacting the design itself, but the less that we require in design, we're going to get these smaller types of steps, because they're like, well, I can get patent protection if I just change a few things, and I can go with that. Whereas if we're in the Bel Air situation, will require large steps of the law in order to get a new patent, you'll end up with pushing the boundaries of design forward. Now, there are economic reasons from an economic standpoint of why we will carrying over that design language. We heard Joey talking about this 80-20 rule, and it really sort of fits into that, because here you're really carrying over quite little, I would say, from one to the next. There is some VBL that does move from this visual brand language from one to the next, but it's much less. But if you move it over to the more current standard that I see, less is required, so a company's able to bring much more of that forward. So who's sort of driving this? Is this sort of the businesses are wanting to have more ability to carry forward their design, so they don't have to have these more drastic changes in design? Or is this something where, on the other side, maybe wanting to enrich the decorative arts, or enriching society with more designs by a policy reason? If we require more for protection from one design to the next, you'll end up with a wider breadth of designs. So I'm going to just follow up with a few sort of things for food for thought here on sort of this equilibrium. And we talk about what is the breadth for infringement we were talking about in the spoon situation, how close is too close, and the idea that that same scope should be determining how close is how different a design has to be considered new or patentable. And so this is sort of the ideal situation where you have your infringement scope. So I come up with a new design, I'll ensnare that amount of infringers, or people who fall within the scope of my design. But on the backside, there can't be any prior art which is just as similar as that design. It takes a little bit to get your head around that one, but that's effectively what's going on here. By setting those scopes, that's what I'm getting at on both sides of the equation, both with respect to infringement, how much we're going to consider as close or too close, and on validity will have some impact on design. At least that's my hypothesis here. You don't want a situation where you have somebody getting in a very crowded art, say for instance of a ton of cell phones, you get a ton of designs, you get your design patent, and then you get to go assert it against anybody who has anything that looks like a cell phone. Okay, you don't want that imbalance. You want it very much what you got. I would say that the reality right now for designs, and this hopefully gives comfort because I know some of my colleagues are primarily utility patent practitioners in the audience, is the reality is that right now designs, the scope is narrow on both sides, on validity and infringement. But the key on a lot of this stuff is if you don't have design protection, if you don't go out and get it on your products, you shouldn't be heard to cry after the fact that say somebody took the appearance of my product. This is the for new products, trade dress aside, because there you have to really get products that have a high amount of volume, sort of an iconic type of look. This is really the only game in town in order to protect that. And it's an area of law that that is burgeoning, it's developing, and trying to make sure that our policy considerations are in line with what the designers and the public would want. So I'll stop with there, and we can hand it over to questions. Thank you.
Alden, are we going to get some people with stronger arms than me to lift some chairs and tables out onto the floor? While we're getting that here, you might want to think a little bit about some of the questions that you might want to pose to our speakers. Where's Elisa? That's all right. All right, the four of us coming up. I've got a few, and I'm going to start the conversation going once we get. Oh, it's chairs. I couldn't have done that. All right. Let's see. Thanks, Jonah. Have a seat. Especially, Lisa, have a seat. Oh, yeah, that makes it completely different. Yeah. Thanks, Chris. Timmy, you go. Yeah. So I want to start. Well, first of all, I want to say thank you to all four speakers for really wonderful presentations and very thought-provoking in a bunch of ways. I actually want to pick up a little bit with some of the questions Chris came up with at the end about the extent to which the design law actually plays, and it's really more a question for you guys first of all, and the lawyers might jump in, is the extent to which the design law actually affects the process. So you mentioned, Joy, that you did a search and you might get some positives coming back. Assuming you get some hits, you say this stuff looks like it's pretty similar. How do you respond to that, and why? And let me just sort of try and explain what I'm thinking is, do you respond by saying, all right, do I have to make a few more tweaks so either I'm going to avoid patent infringement, or do you say I need to make a few more tweaks because I want to make sure this is sufficiently different that I get some protection? And do you do it because you want legal protection or because you think that's going to differentiate something in the marketplace?
Yeah, so am I on? Okay. Yeah, great question. I think from my perspective, as designers, we probably are thinking more about making a bigger splash in the marketplace and not, at least earlier on, not so worried about, splitting hairs and kind of, making sure there's a wedge between the existing and ours if there is an overlap. I don't know, maybe, do you want to add to that?
Yeah, I mean, I come from the cell phone industry, so I'm all about splitting hairs. Like, I mean, they all look the same. I mean, so I definitely, agree with Joey. We're always trying to, find a difference, and I think the key aspect is for me and my work is like, okay, what's the user experience look like? Even if these products are similar, what's the unique experience that the user has? And then, from a design perspective, I mean, like I said, technology industry, TVs, cell phones, there's very little difference just because the functional requirements of these products. So like Chris Karani's, the spectrum is pretty narrow, I think, in those industries.
Yeah, and to add to that, I think, it really depends on the industry as well as the scope of each particular project, because some design projects are more seasonal updates, right, where you want to come out with the next season's model, or whether it's a phone or a car, or like the hairstyling tool project. That was more of what we call a white space project, where it's more more about larger innovation. I don't know if there's a better way to say it, but it's more about maybe true invention versus just a refresh, for lack of a better explanation.
Are there particular types of undue similarity or insufficient splash that worry you more? So, for example, if to what extent is as Chris mentioned, the design pattern system really protects the decorative arts, the appearance? To what extent is that what's driving you versus, for example, the connection between the appearance and the function or the emotional reaction? I mean, what are the sort of the variables of similarity that cause you most concern as a designer, or does that also vary by industry?
I think that varies by industry, but I mean, to prove my point before is, if you think about the very first iPhone when that was launched, that was a white space project. But then the following iPhones were updates to it, right? But the very first one was a real paradigm shift, I think, for communication, mobile communication.
Yeah, so that sort of suggests that there are so many varied forms of design process that in some respects one of the challenges that the legal system has to face, it's trying to come up with a sort of pretty modular legal regime for what actually are a variety of different creative processes. I'm struck, for example, Rotimi, that you mentioned when you're discussing the alt text, right, that in fact you had a brand in the head and then you got the product, which for someone who does trademark and design struck me as an interesting conjunction of the order by which you came to the product. Would that be normal, or is that just because of that particular type of design?
Well, I think one of the reasons that I decided to start my independent practice is because, after a while of working for various companies and clients, there's a real desire to leave my fingerprint on something, and I think part of the reason the brand came first, and it came while I was studying in university. It wasn't alt at the time; it didn't really exist. But the idea was, okay, I want to create a brand that has this meaning. It stands for A, B, and C, and that was whether it happened in 10 years or 2 years didn't really matter. I just wanted to have products that had that sort of a meaning that I feel like, okay, when I leave this when I die or whatever, I leave a good product behind it that stands for something positive or something.
Yeah, a question maybe for the lawyers listening to some of the discussion of the process. If you got a designers come in to you and they say to you, this is the way I'm thinking, I've got this sort of, and maybe they don't come as early as in fact you would want them to, saying I've got this sort of brand that I want to develop, and then maybe some products can follow. Or you describe the process with Joy, which seemed to be more concerned to me the way you were describing it with the other products. Is there anything in those kind of narratives that would make you worried about saying, all right, I've got to guide you a little bit here, or I have to give you advice about the way you behave? Or is there anything in our law at the moment that would make you say, this isn't just suited, this kind of process is not suited for the way our law is structured?
Sure.
I mean, I think it really depends on the client. Some clients, if you have a really big client, they're already going to have done all of that before the product gets to you. And when the product gets to you, you kind of have a meeting and are like, well, we think this could be covered, or this isn't, or this was on a previous product you already did, or something like that. It's not that often that, at least in my limited experience, that a client will come in like midway through the inventive process and say, what else can we do to differentiate it? But it's funny that you bring it up now, because just the other week we did have a client come in that said, we're inventing this is the product that's already on the market, what can we do visually to distinguish it from the patents that already exist? So I would say it's rare that they meet us in the middle, but when they do, it's sort of an interesting, it's an interesting point to kind of like help with that development.
It's sort of interesting, like Chris replies. Well, I mean, you mentioned that, Alyssa. I've always thought that even in a utility patent, the idea of designing around works in some industries, but it doesn't work in others. I mean, there's a lot of inventors in utility patents. I think if you showed them a patent, they wouldn't know what it was unless they owned it themselves, right? But I have the sense that that's really not part of the creative process that designers in ornamental fields particularly have regard to.
Right, at least not that I've
Yeah.
seen.
Chris?
Sure. Two things. I think that the design around aspect of it, with respect to a design patent, is fertile ground. I've in 20 years have only seen maybe a handful of design patents that I could not find a way to design around it. But it usually it's too late in the game. Usually by the time you get it, it's further along. So that would be one of the first pieces of advice to designers is get it earlier in the game so there can be doing some FTO or clearance type of searching if need be. The second thing is when a designer comes and they have this more of a vision and it's sort of a broader concept, is yes, they usually will have whittled it down to one design, but I'm very interested in finding the designs that were left on the cutting room floor. What were those other designs? And if you're trying to build out a portfolio, consider finding ways to protect those or at least preserve that additional subject matter of those let's call them non-elected embodiments.
And do you do that through trying to use other, again, do you use some of the design patent strategy, use a multi-right strategy? I mean, so you've got some of the brands, maybe some of the brand concept maybe on the floor at some stage as well as you refine that.
Sure. I'm really specifically speaking about through the design patent process of finding ways through using multiple embodiments in the course of one application, using appendices, ways to beef up the specification so that you can take into consideration all these variants. Rather than just going with the one rifle shot that you, the designer, had come up with and sort of selected and then deselected the other ones, because a lot of times those non-elected designs are sort of the ripe knockoff designs that people are going to use. So thinking ahead to try to protect those or preserve that subject matter is what I would do if that was approached in that respect.
Well, it caused me to think of, when I look to purchase domain names, they always say, get the package for a little extra, right?
Yeah.
Just so you can get all the .orgs, et cetera. And I think it makes a lot of sense, definitely.
I mean, that's your way of, I mean, I think that's probably very good lawyering, Chris. My question as a policy matter, very neutrally, is to what extent, when you do that, you end up effectively with your triangle of scope and validity being a little bit out of whack, because you end up effectively, right, through the multiple embodiments, etc., perhaps getting a scope of protection that as a policy matter we probably think a little bit undesirable. Right?
Yeah, I mean, from a trademark standpoint, I know, there's a lot written about not wanting to inventory words that we're not going to be using. But here again, with the policy reason is that if that individual, this is to reward the designer, if that designer has created those particular designs, it's really just putting their marker down that they created those particular designs. So I guess I'm comfortable with there. Of course, there is the economic aspect, as designers know all too well, is that, and this is the reoccurring cry, is that it's too expensive. I'm going to come up with 20 designs. I cannot file 20 design patent applications for this one product. And I don't care if it's an individual designer or Samsung or Apple. It's the same refrain. And this is something where I think the Design Law Center would be helpful to try to come up with ways, perhaps influence the USPTO, about allowing for maybe multiple claims in a design patent. I mean, why can't we have that? Utility patents have multiple claims. Why can't designs?
Are there ways in which you guys have produced work where there's parts of your work that have been unprotected and immediately ripped off without any, and there was nothing you could do about it because the lawyers or the advice you got simply said that isn't the kind of thing that's protected? So, Chris was talking a little bit about sort of brand concept behind works, but there's some of the most valuable parts of designs are probably, in many instances, the most unprotectable. I mean, you got any examples that you can share that would have come up?
Yeah, I do actually. A personal product of mine. It's a chair that I designed out of plastic coat hangers, and it has a novelty to it, but it's still functional, right? You can slide the hangers off of the frame and still use it to hang up your coat. So it's not, and they actually, you could sit on them too.
You should have a Kickstarter for that. Sounds really cool.
I'm planning hopefully this year, but I never got it patented because I investigated this years ago when I first came up with the idea, just because I didn't think it was worth it. I mean, I considered getting a provisional, the 1-year protection, but I just didn't have the means to really, do anything with it or bring it to market in time. And it's this weird novelty product where, I certainly could only get a design patent for it. So.
Yeah, I mean, before Timmy answers, I mean, what that might speak to, which is what Europe has, and which there have been many, many legislative proposals for here, is some form of more automatic protection. So you don't have to ask yourself the question, is this going to be worth it? I'm going to get some form of automatic short-term protection, and at some stage, if it looks like it's going to take off, then in fact it's worth me getting the design patent.
And to finish the story on that example, so the route I took was I published it, and put it out there, and it won a slew of design awards, no protection whatsoever. But my thinking there is, just by putting it out there and it's associated with my name, to a certain extent, because it's conceptual, that has value as well, right?
Do you have any particular examples of something you created that just seemed utterly incapable of protection under the regime we have at the moment for any reason?
Yes, actually, I do, and it was sort of very similar situation. It was my senior thesis, what I did with UIC, and it's obviously disclosed, fully disclosed, because you have to sit up in front of a classroom of 30 people, and and it's like, okay, I was doing it to graduate because I needed, I needed that paper, that degree. And so once I left, then I was like, man, this has legs, you know what I mean? So that ended up winning a couple of awards, and I was invited to Dubai to present it, and just kind of blew up a little bit, and got a lot of good traction, and it started to become something that I was like, okay, yeah, this is something that I kind of want to take further, but it's at the point where, in its current form, as a concept, I don't know how much I can do with it without really modifying and changing it, enough to then refile or to then file something.
Yeah, so both those examples that you give are sort of the problems of sort of the process and procedural aspects of patent, extent to which you've anticipation, the extent to which you have to make decisions about costs. But what I had in mind, and I'll throw out one very specific example, and maybe the lawyers can jump in on this, is in some of the arguments that have been made in the last couple of years on reform of design patent, there were at least a couple of scholars who suggested that the piece of true modern industrial design that doesn't properly get protected, and Chris adverted to this, is when we have complete fusion of form, function, emotions, all of that comes together in some sort of perfect storm. But the problem is, of course, is the utility patent system is in mere theory meant to pick the functional part. Design patent is only the decorative. And you end up sort of not quite capturing what is the real essence of the brilliance of the design. I wonder whether is that something that, from a designer's perspective, that sort of gets you higher than anything else, is where it all comes together in those different components?
I would say yes, definitely. I mean, that's always the hope, right? That we deliver on, the functional, the emotional, the psychological. I mean, and it's, I mean, the hope is always to create something that where you would need to get, design patents, utility patents, but maybe there's something missing there, right? Maybe there's another patent typology.
Yeah, I mean, so from the lawyer's perspective, if you've got a client with a product of that nature, which just that maybe may or may not have gotten awards, I mean, do you do it through a suite of the different rights, or is there particular strategies, or are there changes we need to make in our law to accommodate a more holistic approach to sort of protectable subject matter?
Mm-hmm. Well, I guess I'd hit on that is the notion of functionality, I think is the one that it can be problematic. And that's the notion that if there's a particular form of something, that's the only form that could achieve a particular function, we don't want to give design protection to that particular form. And by way of example, say you had a ball bearing, and this is before ball bearings came out, and that if you were to provide a design right to cover that particular shape, this sphere, which is the only way that you could provide these minimal coefficient of friction, whatever, that would be basically usurping the utility patent in that particular case. So limited to that particular spot. But there are very, very few things which can be monopolized with the design right. In other words, very, very few forms or functions that can only be executed through a single form. So that's one area where I feel like the laws narrow in that regard, and it rightfully so, because I think we're just trying to guard against the monopoly concern. But outside of that, it should even be interpreted even more liberally, because there's a lot of these ideas. For instance, when you were talking about the curler or the appliance with the particular right angle on the handle, that idea alone seems like something protectable, irrespective of what is the shape or the cladding on the outside of the housing of that particular aspect. And that's the thing that I could get confronted with a lot of clients is, from the design standpoint, is like, I have this, I don't want to just claim the outer housing of it, it's that configuration that I'm interested in. And that's a tough one here in the States without utility models that we have in other
Yeah,
countries.
you're right. I think it is it kind of teeters between the two, and I think Alyssa shared the chip example, which its form is inherently part of the function and what the value that it's providing, in the ridges or the ruffle. I think yeah, you're right. I agree. The L shape, I mean, clearly it's very different visually, but it's adding. I would argue the function of that shape is actually higher value than the visual, right?
Mm-hmm.
So, yeah, you raise a good point.
Alyssa, do you want to add anything to the questions of trying to get in the gaps between the different forms of value?
I guess my main issue with the gaps in different forms of IP protection is the amount of time it can take. And I'm speaking purely with utility versus design. And when you think of the visuals, like a pair of shoes is only going to be popular for so long. Like these shoes I'm wearing right now might be nice for like the next 2 years and then go out of style. If there's a utility patent on it and it takes 10 years for it to prosecute and grant, who cares? Like, what's the point of filing that utility patent? But if there's a design patent and it issues, if it's expedited and issues faster, or, even if it's not expedited, it's going to issue in 2 years or something, then the protection is kind of worth that money and time that you put into it. So, I mean, the reason why both of them take any time at all is because the PTO is totally backed up. But if they could sort of reduce that time, it would make
I mean,
work
maybe that
together
again
better.
is something speaks to adopting something like, not to push this too much, but adopting something like the European short-term unregistered forms of protection, which I think would be useful at least in industries that are a little more faddish,
Right.
with a quicker turnover of the season. So I'm taking some guidance here from Dunstan, but I mean, have we got time just for a couple of questions from the audience? Yep. Do we have any questions from the audience, either the lawyers or the designers? Yes.
This is for Chris. Reading the tea leaves a little bit of the Supreme Court, it seems like the Federal Circuit's been pretty interested in design lately. Do you think the Supreme Court is going to take any other cases anytime in the near future to try to fix the 102, 103 that kind of move we got going right now?
Sure. Well, that's certainly a good a problem, the 102, 103. So before 2016, it was 1871. Since the last time the Supreme Court took a case, well, maybe 1890s, there was another short opinion. But with that, it's been a long time. There are certainly some issues that are ripe for their determination. It's going to take one of these big cases, and it might end up still being this damages issue that went up to the Supreme Court saying it's the total profits of the entire phone. The question was on the iPhone, where it was just the bezel of the phone was claimed. It was a partial design. And so the question is, do you get the full profits of the entire Samsung phone, $700 phone, or do you just get a portion thereof? And ultimately, the Supreme Court said, I think much to the surprise of a lot of people who are part of the sort of the opposition party, I guess, against designs, was that it should be limited just to that particular component. But the Supreme Court said it can be either, and then kicked it down to the Federal Circuit, to the District Court, to the Federal Circuit. I think on those type of cases, that case ended up settling, but that might be one of the cases, because it's such an important decision about what will be the test for that.
Any other questions for any of our panelists? Well, I've got one more, Dunstan. I have time for one more, and then we can go to food. Right. So it's one that actually I think I've had discussions with Chris, given his most recent book about, but I've had discussions with colleagues in Europe as well, which is, one of the themes that comes through both in the extent to which something is truly inventive enough to get protection, and or whether there's a countervailing reason for why we shouldn't, for monopoly reasons, give something protection. It's the extent to which designers are constrained by particular concerns. And this debate is, are designers only constrained by basically function? The thing still has to work, right? Your thing still has to be a chair that people can sit on, right? Are the constraints that you fight against and try and overcome, can you classify them by saying sort of function is always a very hard one? Aesthetics, we can always find another way to make it look, or any other consideration take into account. Is there a sort of hierarchy of the stuff that is harder to get around, where you've got less room to wiggle, as it were, and be creative?
Oh man, that's
I can probably start this one. I mean, I guess the constraint for me in a lot of my work would probably revolve around the form. I think that in a lot of what I work on, I'm working with a team or with someone else who's hired an engineer, and so a lot of the functionality may be predetermined sometimes for me. So then it's within, okay, what can I do with the form? And because I work on the electronics industry, there's more than one right answer, but a lot of times it feels like there's really one like optimal answer. And maybe that's me being, a designer. It has to be this way. But once you examine, okay, the amount of space that you have to work with and the usability and everything around that product, sometimes there's an optimal package, And so if there's an instance where this optimal package is maybe in danger of infringement, then that becomes a really challenging situation. And it's definitely my first course of action would be, okay, back to the drawing board, and understand the scope of that infringement and see, okay, what can I do to maneuver? And at that point, it becomes, really pulling hairs, because I've predetermined that this is the most appropriate form for the product. So how can I still try to get that essence, but in a way where I'm not infringing and I can get away with it. Something bad.
I was gonna say, and there's been this trend, I don't know, maybe the past 5 or 10 years where I feel like a lot of the differentiation in the industrial design is maybe less on the primary form and more on the secondary or tertiary aspects, which I suppose from an IP point of view would just be the details. But you see it in a lot of the faceting of the surfaces and the plastic, I think the primary forms usually, you see the trend of them, being distilled down to these primary shapes, like the ball bearing example, or, I'm trying to think of an example here, consumer electronics, but the Jawbone jam box, that product. So that was kind of the height of that trend, where it was purely these rectilinear forms, but what really made the design different was the way that the fascia was treated, right? Those little grill patterns and how it was formed, and that's really what, if I had to guess, was the differentiator in terms of, ownable IP.
And would you call packaging? It's this interesting example in terms of the pen, which is very creatively packaged. Would you call packaging as a subsidiary form, or is that a sort of product design in itself to design packaging? Would you think of packaging as a separate? So the way you were describing it, you had it quite integral. The pen and the packaging were all part of the essence of that particular brand, that particular idea. Do you think of it as a subsidiary, or am I putting words in your mouth?
Yeah, no, I definitely think that product and packaging are, packaging is a product, you know, so if I have a project where I have product and a packaging requirements, there's just two projects, basically. I think what makes packaging successfully done is how it integrates back into the product. But I do consider those separate, and I look at them from some separate lenses. I try to tie them back in together.
Well, I know I've already kept us going. I apologize. Please join with me in thanking our speakers.